What's going on, everybody? This is Lady Luck here again. Thank you guys so much for tuning in. I just wanted to do a quick video on some information regarding what's considered to be federal stalking harassment laws so that you're aware of what the jurisdiction that, let's say you want to file a complaint with the FBI, what they would have, and what needs to be included in your complaint if you do seek that type of legal recourse. So, one thing I'm a firm believer in is, of course, reading, researching information. And if you're not quite sure on how to interpret and understand laws, you can always first and foremost consult an attorney, but also go to case law to give you a better understanding of how certain laws are interpreted in other cases in court. So make sure you guys hit that like button and subscribe to the Lady Luck Club. We're aiming to hit 30,000 supporters by September 30th. I believe that we can do it, and I cannot do it without you all. Also, consider becoming a member of the Lady Luck Club. And at the end, I will give some information on our partnership with Dr. Squatch and products that can be purchased that are tagged. So let's get to this. I have it's gonna be a quick video, you guys. I just want to make sure that this information is out. Um, you can go on legalclarity.org. I'd simply just Google the information so that you guys, anyone that watches this video, can have an understanding of what would fall as a, under the federal jurisdiction of any agency that investigates these types of allegations and complaints. So, according to 18 USC 2261A, as an Apple, federal stalking and harassment laws um, are defined. So, we're going to go through this. I'm not going to read the entire article. I am going to leave the link of the article in the description of the video so that you guys can read over this information. And like I said, consult with an attorney or you can do further research to have a better understanding. So, federal law provides serious consequences for stalking harassment, particularly when these actions cross state lines. Here you go, or involve electronic communications. So, of course, there seems to be a whole lot of cyber harassment, cyberbullying, and stalking and doxing going on. No one can tell you, unless they work with the FBI or they're an attorney, that you cannot file a certain complaint with a certain organization or agency such as the FBI. And no one should have to be subjected to intimidation or threatening behavior of any sort or retaliation for doing so. We all have the right under the U.S. Constitution to seek legal recourse in the court of law. I don't care how anyone phrases it, weaponization, frivolous, I don't care. That is for the judge to decide. Not someone without a law degree, the judge. And if anyone is confused about what the FBI in particular covers as far as complaints that are filed, you can go on the FBI website and they have all of the major complaints that they do have jurisdiction over that falls within their purview. That is on the FBI's website. So having the information you need and being empowered, it diminishes anyone that tries to state otherwise, especially when it's not factually accurate. So as you can see, if it's happening online and it involves electronic communications, this would fall under the federal jurisdiction. So filing a complaint to the FBI would be appropriate and it will fall under their purview. So under 18 USC 2261A as an Apple, individuals can face criminal charges if they engage in conduct intended to cause fear, distress, or harm to another person. This statute addresses both physical and digital harassment, reflecting growing concerns over cyber stalking and online threats. So you guys see that there for yourself. Stalking and harassment under 18 USC 2261A involve behaviors that place a person in reasonable fear for their safety or cause substantial emotional distress. You guys can see that here. The law criminalizes following, monitoring, or repeatedly contacting someone with the intent to intimidate or terrorize them. Unlike state laws, which may require a pattern of behavior over time, federal law, and I'm just reading it here, you guys, read along with me. Federal law applies when there is specific intent to harm or frighten the victim. Federal law applies when there is specific intent to harm or frighten the victim. Courts have ruled that the accused must knowingly engage in conduct that would reasonably, and when they say reasonably, mean to the average person. And especially, if you think about, let's say a case goes to court, you're going to have a jury trial. So, what would be reasonable based on how the average person sitting in that jury would basically define it or see it to be? So, for that would reasonably cause fear or distress. The statute also covers indirect actions such as using third parties to harass or intimidate victims. Even if an individual does not personally contact the victim, they can still be held accountable if they direct others. Now, this is under federal law, under USC code, under the US code. If they direct others to engage in threatening behavior. So there's no reason to guess or theorize. You can read and research. This information is here. And this is just one website that would have this information. Several websites. You can go on cornelllaw.edu. I pretty much would go based on the actual federal statute itself. So oftentimes I just look up the law to see how the law defines harassment or stalking or doxing. And then based on the requirements for that law to apply, that is how I go about if I had to build a case and get evidence and documentation. That's just one of the ways you can do it. And you'll be in accordance with the actual law itself. So federal law, of course, the standards for it is not the exact same as state law. So you have to be careful in what you're reading, and if it involves interstate commerce, or if it's electronic, or it's anything on the internet, that would meet the federal jurisdiction standard. So that would fall under the purview of the FBI. All right. So the statute also covers indirect actions, even if the individuals that does not personally contact the victim, they can still be held accountable if they direct others to engage in threatening behavior. So when Umar Johnson, Prince of Pancrust Pizza wannabe cult leader, is out here telling his brainwashed cult followers to go out and to dox someone or to get information on someone that includes personal identifiable information, and doxing is illegal, they can also be held liable for directing the person to do it. Courts have upheld convictions where perpetrators orchestrated campaigns of intimidation through intermediaries, so through third-party individuals. And if people are dumb enough to do that, knowing that it's a violation of federal law, then name their ass in the lawsuit and keep living, or in the complaint, because they got it coming. Unwanted physical presence, such as repeatedly showing up at a victim's home or workplace, can also constitute stalking. Courts have ruled that even nonverbal actions, such as loitering near a victim's residence or sending unwanted gifts, can meet the legal threshold if they contribute to a pattern of fear-inducing behavior. The law does not require the victim to explicitly express fear. Rather, it applies if a reasonable person in the same situation would feel threatened or distressed. If a reasonable person, once again, you see this language of how reasonable it is to the average individual. Okay. So, requirement for the interstate element. For federal jurisdiction to apply, the government must establish an interstate nexus in the alleged stalking or harassment. This means the conduct must involve travel across state lines or the use of a facility of interstate commerce, such as telephones, mail, or the internet. So when all of this nonsense is going on Facebook, Twitter, Instagram, YouTube, X, or whatever it's called, any platform that is internet based or over the internet in general, Or if you're getting text messages and phone calls, most people don't use standard mail, but let's say you get something mailed to you. Yeah, that would fall under this federal jurisdiction because there's no way to say that this action done over the internet happened in a specific state. So, federal law, the requirement of that says, okay, if it's, for it to be interstate, we have to include electronic communication because there's no way to just say that the other person that's sending the text message is in the same state where the recipient of the text messages or the harassing behavior is located as well. All right, so this requirement distinguishes federal stalking laws from state statutes. So that's the difference right there, which often apply regardless of state boundaries. Courts have interpreted the interstate requirement broadly. In United States v. Bowker, here's case law here. You guys can look up if you want to see some case law that relates to how this particular USC code, US code, I'm sorry, has been interpreted in court in other cases. So, US v. Bowker, the Sixth Circuit upheld a conviction where the defendant made threatening phone calls across state lines. Similarly, using the internet considered a channel of interstate commerce can trigger federal jurisdiction. So, I find it laughable for anyone to dare be, intimidating or threatening and trying to deter someone from filing an FBI complaint, or to find it disgusting when the FBI has actual jurisdiction over, cyber harassment, cyber crimes in general. That falls under their purview. This is a fact. And like I said, the FBI website is a great resource as well. So even if both parties reside in the same state, sending messages through an online platform that routes data through multiple states must satisfy this threshold. Physical travel by the perpetrator also establishes federal jurisdiction. So if someone and it goes out and they show up at your house and they cross state lines, and you can prove, and there's evidence that they do not reside in the same state you do, and they cross state lines to come to your home and harass you, that also would establish federal jurisdiction. So in US v. Wills, here's another case law here. So it's case law cited. The Fourth Circuit affirmed the conviction after the defendant crossed state lines to intimidate the victim. Even a single interstate trip, here it is, even a single interstate trip undertaken with intent to harass can justify federal charges. So if someone shows up at your house and they gone out and said, here's proof that I've flown to your state I don't live in, just for the intent and purposes of harassing or stalking or threatening someone, yeah, you can contact the FBI. That falls under their purview. The worst thing is anyone trying to infringe upon the rights of others for seeking legal recourse. That is not for any person, especially if you did not go to law school, to determine whether or not something is frivolous or someone is sitting here weaponizing a court. That is for the judge to determine, and the judge only. So if you have to seek some sort of legal recourse, the best thing to do is do what you need to do, and then you let the defendant find out the hard way. But it's not for anyone to determine but the judge whether or not a complaint was frivolous or weaponizing the court. Let the judge make that determination. The law focuses on the accused's actions and whether they leverage interstate movement to facilitate the crime. So you have here a segment on online and electronic activities. The rise of digital communication has expanded the scope of stalking and harassment under 18 U.S.C. 2261A. Cyber stalking includes sending threatening messages, publishing personal information here, that's part of doxing, without consent. There you go. Publishing personal information without consent, doxing, and creating fake profiles to impersonate or defame victims. So when you're seeing multiple profiles pop up and it's someone else's name, that's not the person, but they're using that fake profile to go and stalk channels and read comments in the comment section and this here and make it known that they're stalking people. Yeah, no, we don't do that. Not under federal law. Federal courts have ruled that the persistent online harassment, whether through social media, email, or messaging apps, can meet the legal standard if it causes substantial emotional distress or places the victim in fear. No one gets to determine that. Just gather your evidence and then you take it to court and let a judge rule on that. Direct threats are not required. You see that right here? Threats are not required. So no one has to say, I'm going to take your life if you do XYZ. It's not a requirement. It just needs to be, as far as meeting the legal standard, a matter where it causes substantial emotional distress or places the victim in fear. All right. A pattern of intrusive behavior, such as constant monitoring or repeated unwanted contact, can be sufficient for a charge. A pattern of intrusive behavior, such as constant monitoring or repeated unwanted contact, can be sufficient for a charge. Cyber stalking causes digital footprints to be left behind to which that can track movements and be traced back to the person doing the cyber stalking. It's best if you don't like someone and you have some gripe against them to leave them complete alone. Constantly going on their channels, watching their videos, and leaving comments or directing third-party individuals to intimidate or to harass someone can warrant a criminal charge. Just keep living and leave the person alone. It's that simple. There are 1 billion users on YouTube. Surely you can find someone else to go watch. That's how I see it. All right. And then they have case law here cited U.S. v. Petrovic, Petrovic, Petrovic. The 8th Circuit upheld a conviction where the defendant distributed private images online to intimidate the victim. I think I've heard this happen before. So these cases give a good example based on the allegation of how the same USC was interpreted in court and how it dictated the ruling from the court. So distributing private images online to intimidate someone, I mean, that's obvious public shaming and humiliation. And that does fall within the definition of actual cyber harassment. Courts have also ruled that tracking a victim's location through spyware, GPS devices, or hacking into personal accounts can constitute stalking. These cases demonstrate the electronic surveillance and digital intrusion are treated as seriously as physical harassment. So, law enforcement uses forensic tools to trace digital footprints because, laws are laws, and she who knows the law has the power. So, yeah, keep on leaving those digital footprints behind, and it will catch up to you. So, law enforcement have the ability, especially the FBI, to utilize forensic tools to trace those digital footprints, including IP addresses, metadata, and encrypted communications. The FBI Cyber Division, look at that, and local internet crimes against children ICAC task forces assist in investigating cases where perpetrators use anonymizing software anonymizing software. You're trying to remain anonymous, basically, or encrypted messaging platforms. Prosecutors have successfully argued that attempts to erase online evidence or use burner accounts to evade detection demonstrate a calculated effort to continue harassment. You cannot have a burner account or try to utilize and abuse NordVPN or to, evade detection and say that you did not intend to harass someone. That is purposeful and is planned if you're using those types of measures. Even when perpetrators operate under pseudonyms, subpoenas issued to social media companies and internet service providers can uncover identifying information, allowing authorities to pursue charges. So, yeah, you can pretend like you're hiding it, doesn't work. So here you have the penalty section. They can violations of federal law, of course, can carry severe consequences. It can result up to 5 years in federal prison if the stalking or harassment does not involve bodily injury. If the conduct causes serious harm or includes a credible threat of death or physical violence, the sentence can increase to 10 years. So you're talking about facing 5 to 10 years over some nonsense on YouTube. Is it worth it? Umar, you Prince of Pan Crust Pizza, and any other wannabe cult leader, is it worth it? Judges consider aggravating factors such as prior convictions, restraining order violations, because that is a thing, or the use of a dangerous weapon when determining the appropriate sentence. So, this information here, you guys can continue to read protective measures that are in place that you can utilize. If I were you guys, I would definitely check out this article. It is very helpful. And when push comes to shove, you can always go to the FBI .gov website and to get more information and clarity on the purview that would fall under the FBI. They have an actual website. I think it's ic3.fbi.gov, where you can file complaints online to the FBI directly and have your evidence and documentation. You can link and attach to your complaint, be able to describe in detail what occurred, and your exhibits or your documentation needs to support your complaint. So you would rather file it and allow the FBI to tell you whether or not it's viable and they're going to approve to move forward with an investigation on your complaint, as opposed to be intimidated and not doing it because, you know, people aren't attorneys and they can't make that determination either way. So if you decide to do this, make sure you have sufficient evidence and make sure, the claim is valid and you can actually state what occurred. Not just a blanket, oh, they're harassing. No, you have to be specific in the actual incident. Be able to state date, times, provide links to videos or posts or text messages or emails or however, the harassment came your way. And I would encourage you all to consult with an attorney, because I'm not an attorney. I'm not a legal analyst. I just read and research, and my godmother's a federal judge. That's it. He who knows the law has the power. I just happen to have it in human form, and I bless God for that. All right, y'all. That's it. I just got to get that in. Umar is out here wilding out. Got these wannabe cult leaders wilding out, and people are just kind of getting sick and tired of the nonsense. And, after this year of seeing, content creators go to Vegas and, one man shot, a husband and his wife out there over some YouTube beef. And then, of course, what the world witnessed with Charlie Kirk. I mean, you can't unsee that. All because, difference of opinions and ideas. Here's an option. You have a choice not to follow that person. You have a choice not to watch their content and their videos. You have a choice to leave them complete alone. That's it. No one owes anyone any loyalty or anything. Just leave them alone. That would be your best bet. All right. I hope you guys, find this informative. Thank you all so much for tuning in. Make sure you check the description of the video for the Dr. Squatch products that will be tagged. We have a partnership with them here in the Lady Luck Club. I do receive a commission on the sales through the purchase of the products that are tagged in the video. So that goes back towards, the support of the channel. Shout out to Dr. Squatch as well for that fantastic partnership. Thank you all so much for tuning in. Hit the like button, share the video, and subscribe. Let's hit that 30K by the end of September. And until the next one, Lady Luck Club out.